I'm Scott Goddess with Barnes & Thornburg. I represent policyholders and insurance coverage disputes and questions. Joined by Tom Sorrell immediately to my left, Executive Vice President with Willis. And to Tom's left, Suhey Navarez, Professional Risk Counsel, Cyber and E&O with ACE North America. To her left, Sarah Stevens, Head of Cyber, Technology, and Media and E&O for JLT Specialty. And Mary Moorkamp, General Counsel and Secretary to Schnook Markets, Inc. So, I'll give you the roadmap of what we'll talk about, which is provider selection, notice, sublimits, incident preparedness, and onboarding and avoiding trapdoors. All right, let's start out with, in terms of provider selection, outside counsel and vendors, it's no surprise to anybody in the room that policies typically have a listing of or a request you go to the eRisk Hub to find your providers. And that entails both legal counsel, forensics, notification companies, and otherwise. So let me start. I'll turn this to Mary. Mary, one of the points that policyholders have to keep in mind is that cyber insurance carriers pretty frequently want to have the claim investigated and defended by panel counsel. So, but you're a company that I'm sure hires law firms pretty regularly. Can you tell us about your ordinary practice in hiring law firms?
Well, our ordinary practice is we have a small in-house shop. We have 5 attorneys who definitely handle the day-to-day bread and butter. For anything that's highly sophisticated, complex, and or requires a deep knowledge of a particular area, we outsource. So at any given time, we probably have 10 to 20 outside law firms with whom we regularly deal.
But are any of those firms people that you would consider to be experts, even though lawyers aren't supposed to be experts in anything, when it comes to data privacy?
No.
And you've worked with a panel counsel firm, not to hide the ball. How did you end up using the firm, and could you give us an overview of your experience?
So we ended up using the firm. We had 5 firms that were listed in our policy, and we interviewed those firms as well as reached to our outside partners for recommendations and came down to the firm that we ended up using, and it was a fantastic experience. As much as you'd hate to say going through a cyber breach, it was a fantastic experience, but legal counsel was great.
In contrast to that experience, I know policyholders can be hesitant about using panel firms. There are questions about dual loyalties, and are they loyal to the insurance company or are they loyal to the insured? And obviously ethical considerations are there, but beyond that, did you have any concerns about, let me start with the experience question, when you were looking at the 5 firms and the one you ultimately chose?
No. We knew the firm that we selected had significant depth and breadth of cyber experience. It was critically important that this had to be a gold standard firm that knows this stuff in and out because it's so complicated. And using one of our typical litigation firms was not, we didn't want to be the test case that they learned on. So as far as that goes, no concerns.
Were there any concerns or pauses about dual loyalties or things like that you might see in other contexts?
I can see, honestly, for like the split nanosecond at the beginning of the engagement, my head was going, oh, this is a firm, it's by the insurance policy, it says. But that dissipated very quickly when it became very apparent that the firm represented us. We had a self-insured retention that was not insignificant, and we really know that we did not get a cut rate, fly-by-night kind of a law firm.
So, hey, let me ask you, I don't want to use the phrase carrot and stick under some policy. I'll go with this. Let's say your experience, preferred providers versus firms that are not on the so-called magic list. Can you tell us about how carriers, generally speaking, set themselves up, set policyholders up in a fashion where maybe there's incentives, maybe there are disincentives, or how that plays out in your experience?
Sure. So many of us know that a lot of the specialized and more experienced carriers here provide their policyholders with access to these professionals and experts in these fields, and I would say that access to these highly experienced, extensively vetted professionals, and also professionals who are brought onto these panels and sometimes pretty competitive, pre-negotiated rates are one of the most important protections that are provided to policyholders under these policies. Based on our experience, claims experience from my claims days at ACE, I would say that we typically saw that, having access to these panel members, and when they were retained, they saved our policyholders both time and money when they were navigating through the breach response. And certainly, while it's not always the case, or necessarily in a majority of cases, I have seen converse when the policyholders used their own preferred providers and mistakes were made. And typically where this arose was when the policyholders were tapping into their outside, just general corporate transactional counsels that did their general E&O defense work with no experience in breach response, and basically sometimes in certain instances charging double or triple the rates that what our panel firms would do, and mistakes were made. So from our perspective, we can certainly make the breach response process more cost efficient. Basically, these panel members can also, importantly, help our policyholders prevent future harm and risk, because they're helping them execute a proper breach response. And it's a matter of helping our policyholders protect their brands and, in certain instances, their livelihood by using the available resources that are allotted to them under the policies.
There are situations in which, perhaps not specific to cyber insurance, where this comes up in D&O quite a bit. There's talking about what I'll refer to as the stick approach, and I won't put that on Suhi's. I'll take that out of Suhi's mouth. I wouldn't want to ever say carrot and stick. But if you're in the spot where you're used to the stick approach, which is use these firms or else, or if you don't, we're only going to pay a certain amount in terms of hourly rates. You have experience with a carrot approach where perhaps there are incentives provided for using particular preferred vendors.
Sure.
Can you tell us about that?
Sure. So, and we'll take a step back. I think this is one of the reasons why it's important for policyholders to understand the coverage that they're buying. Certainly, there are carriers that will basically, in order for you to get coverage for your breach response, you have to utilize members of their panel. I think the carrot approach, as you coin it, or as you use it, applies to those policies where insureds are under no obligation to utilize the vendors that are provided by the carrier in order to get coverage for those breach response costs. And there are policy carriers like ACE that will allow generally the policyholders to utilize their own vendors, but will provide those extra incentives, coverage enhancements, if you want to call it that, where if they do utilize members of the panel, they'll get things like an additional or larger limits of liability, or in certain instances, a $0 retention for the use of the data breach coach. And also, just one of the things that I've started to see increasingly is in certain instances, policyholders are basically bringing in their preferred providers and adding them on by endorsement as part of the carrier data breach team. And certainly this is before an incident occurs, pre-claim, and ideally pre-binding or during the renewal process.
Sarah, that leads me to my next question for you. What's the state of the market as to willingness to add on particular providers at the time of binding? And perhaps just as significant, how many policyholders think about that at the time of binding versus time of claim and say, we use X, Y, and Z firm, we love them?
Yeah, I mean, I think it fully depends on new buyer versus renewal. So I think it's a really interesting point you talk about, endorsing your preferred providers on versus using a panel, right? If you've been using a panel because you've been buying for 3 or 4 years now and you're used to that panel, then you switch insurers, they've got a fully new panel, you probably want to take all those people with you that you're now comfortable with, especially if you've had an incident or two. But in terms of willingness to sort of endorse that on, I think normally the challenge is actually for the insured to know who they want to use for what services and to get that into the policy in a timely manner. So best practice, absolutely. Talk about it up front, talk about it in advance, and get all of that established. But it sometimes doesn't work out that right. If you're trying to bind a policy for the first time, there can be coverage issues. It's about pricing. It's about getting all those loose ends tied up, and that can be something that just creeps and creeps. Not a great situation to be in if you then come to the time of a claim.
Tom, in your experience, have you seen that written in, and have you had experience with the question then ultimately of hourly rates? One of the things with panel counsel that's listed in the policy have the benefit to the carrier of pre-negotiated rates, but when you're dealing with an endorsement like this, how does that work out as to saying, here's what they charge me, and here's what I'd like to have covered.
I'm not taking questions today. No, it gets down to what the insured is most interested, obviously, in all the things we're discussing here. A lot of times larger insureds want more flexibility. They have procurement-driven processes internally where they have to vet their own various vendors across the spectrum, lawyers and breach response, and even brokers and insurers. Getting those types of organizations locked into a policy or an endorsement, which is just difficult for their own culture to deal with, can be problematic. A lot of times smaller organizations are looking for the guidance and advice that comes along with that type of thing. So, I mean, I think for a broker point of view, you have to know your client. You have to know their organization and know their culture. And I'll even go a step further. It's a broker's responsibility, depending on which ultimate program everyone agrees is the right fit, that is implemented. And it's not implemented with the binder letter and the transmittal over to the client. You've got to help that risk manager, help that CFO, treasurer, whoever you're working with, getting this process done, because we all know, as we're going to get to in a few minutes, that the time to onboard these vendors, the time to pick on the list or not pick from the list, it should really be done in advance of the breach, not in the 90 minutes after you get the first call where everything's on fire. So did I answer the question?
Absolutely.
Well, and even I would just add to that, like ideally, market selection and who you're going to place that policy with, that's about how the claim is going to be handled as well. It's not just about the cheapest price. I know we're going to come on to that later, but that's part of that process as well.
Have either of you, Sarah, Tom, dealt with a situation in which you are dealing with 90 minutes after their incident is learned about? There's a question of, we want to use our law firm. These guys are great. They've been helping us with and our corporate stuff, and though they're expensive, they've got a great privacy team, and we really want to use them. Are there secrets, or in your experience, what has helped, if at anything, getting to yes in terms of saying, I know you list the following 12 awesome law firms, but our client really, really, really loves these people, and we want to use them?
So, I mean, there's always the normal argument about, it's a firm that's familiar with the insured, and therefore there will be efficiencies there. There's not like a getting to know you process. But, I mean, I've definitely been in that situation where you're scrambling and you're pulling the privacy practice part of the website of that law firm and sending it over to underwriters to say, are these guys okay? But certainly it's always better if you were able to do that in advance. In the cases where you're not, I think it's just a negotiation. And it's also, I think, about talking to your client in some cases, right? There may be a reason why that firm that handles all of your normal corporate litigation isn't the right firm, and really you should think about, this firm has handled 100 data breaches this year. Don't you want these guys on board?
Absolutely. I'll add, I've worked with a lot of clients who've said things like, hey, when we understand this now, it's 90 minutes later, we're going to do what's right for our firm. This is our reputation. This is our wherewithal. This is, our company. Regardless of what the rules and regulations and policy, we're going to do what's right for the company. Now, getting them to remember that conversation 6-8 weeks later when you're trying to actually settle the claim and you're having these arguments, remember when you said you don't care? So that's definitely something you have to weigh and balance in there. But yeah, I mean, negotiating that after the fact is a difficult thing. You're not negotiating from a point of strength at that point when you want to change what was all agreed to up front. So if you're going to have those agreements up front, I found it best to get that information into all parts of the organization as quickly as possible, not just the risk manager or the insurance buyer. Get it to the general counsel, get it to other folks, as information security officer, folks who will be involved throughout the process of these types of claims.
My personal favorite. Oh, we went one too far. There we go. Late notice, best practices. So, Tom, this is the least favorite thing of coverage counsel, at least on the policyholder side, is dealing with late notice. But so what do you see as some typical sticking points when it comes to late notice?
There's no sticking points when it comes to late notice, right, Beth? So our claims attorneys and others that in the room here included still tell me one of the biggest or most common reasons claims are fought or denied or initially declined is late notice, believe it or not. It's not the sophisticated this, that, or the other in the cyber world. It's plain old, we just didn't tell folks over at the carrier in time. And what are the big reasons? What are the sticking points for that? I think one of them is some cases the insured and the folks involved there, and this can be even the IT folks and the information security folks, don't understand the broadness of the term claim. A written notice, in different policies, of course, but understanding that when someone sends an email complaining about something, that could be construed as a claim. Obviously, on the breach side, it's tends to be a little easier, but it's still, of course, tricky on the breach response side as well, not only on the liability side of the programs, but helping them understand, again, not only the written insurance buyer, they typically do understand what a claim is, and when they know about it, they will report it, most cases. Getting others in the organization, especially those who aren't familiar with insurance, to understand the broadness of that term and the obligation and duty that happens when you have there. The other one is, other big sticking point on that causes late notice issues is the organization looks at an event and they don't think it's a big deal. And the problem is, of course, how do you know it's not a big deal? None of us have a crystal ball. We can hope it's not going to be a big deal. We can, in our experience, we don't think it's going, we've got a large retention, whatever the case may be. And so I know our claims advocates are always talking to our clients that get that information in as quickly as possible, as soon as you know about it, even if you think it's not a big deal. I think later on we're going to talk a little bit about bordereau and volume and dealing with those types of things. But I guess the crystal ball perception is another sticking point.
Suhei, I've had a situation recently in which it was a small event, and for whatever reason, there were internal discussions about whether to send notice or not. Notice ultimately was given. The insurance claims adjuster, to his credit, said, well, I could have raised late notice, but I prefer that at least you took steps to start mitigating your harm, and let's move forward, and sort of suggesting that there's discretion amongst the claims team. Have you dealt with situations in which you've been able to exercise discretion about notice, and what goes through your head when determining whether to say late notice, too bad, or late notice, but hey, you were taking steps and we'll step in and get your back now?
Sure. Well, I would have to say that ACE has the best policyholders in this case, because I didn't really grapple with this issue much when I was in claims, fortunately. Very often what we see is our policyholders are reporting these incidents within days of learning of them, or sometimes as soon as the same day of. So I really didn't have much of an opportunity to deal with late notice. But one of the things, and just again, and I mentioned it before, maybe it's the lawyer in me, but it's so important to understand the coverage that you're buying, certainly, and this includes the reporting obligations. These are claims made and reported policies by far and large, so they are time sensitive. And certainly with the lack of standardization between terms and within the different policies, you're going to have different reporting obligations. So you may have some of those policies that require notice as soon as practicable within the policy period. Others that require you to provide notice within an average or a range of 30 to 90 days after that claim is made. And others even that allowing a claim to be accepted as long as that insurer is not prejudiced by the delay. So I certainly think it's a best practice to report those claims sooner rather than later. And certainly depending on the carrier and also the policy terms and provisions, a carrier may not necessarily also pick up those costs that were incurred before notice is provided. So to the extent that you have a breach, you have to respond to it, and you have to incur those costs, you would want those costs covered and eroding the retention so that you thereafter attach to the carrier.
Mary, one of the issues I know policyholders face is the question of the silo effect, where you've got the risk managers not necessarily in communications with the CIO or whoever is dealing with sort of the initial incident or legal counsel. There's not coordination regarding notice and defense. So how do you make sure that legal and risk management personnel, to the best extent possible, stay coordinated to give notice and work together and make sure that everybody's operating as a team rather than doing their individual thing, and someone later on says, well, why wasn't notice given? I didn't even know.
Well, to the extent there's a silo, it's within my department because all of those report through me. So we regularly, if there's an incident of any sort, we have an incident response. We call them kind of the SWAT team, but they have the relevant people that are brought together. So if there's an issue within InfoSec, we partner with our risk attorney who partners with our insurance, who partners with our finance, and that's our team that does the triage assessment of, okay, what does policy say? What do we have to do? So, I'd say we may be a little different, but that's kind of our keep it front and center.
So the idea that risk management is baked into legal so that you immediately look at insurance the minute anything comes around.
Mm-hmm.
I think if everybody operated that way, there would be no late notice case law out there. So, Tom and Sarah, tell us about your experience about clients that face multiple small or nuisance or otherwise types of claims and their efforts to wrestle with giving notice. So if they've got thousands of claims, what's been the experience in terms of dealing with that situation? And claims could be capital or small c here.
Well, I think it's always a difficult issue that you kind of grapple with when you're sort of first setting up what the policy language should look like for a particular insured, and you're always thinking, just like Tom said earlier, a lot of clients might think, oh, this is going to be a small issue, or we don't want to report nuisance claims. And I do really think it's about knowing your client. And so if there is, within a certain organization, you have a way that you classify information security incidents, right? And so we can all agree that when, I have one client where we've got written into the policy when the in-country incident management team is activated, which is a very specific protocol, that's when notice has to be given. Or, when it's a Category 3 incident, that's when notice has to be given. Or you can always go with, if we think it's going to cost above X, then that's when notice is given. But, it's a really difficult issue, and if you don't talk about it, then you just get that judgment call at the time of, oh, this isn't going to be a big deal, and then it's the next target.
That's right. A bordereau or a periodic list of claims that you put in rather than reporting as they come it can be very helpful, especially in low frequency, high severity situations. Healthcare and managed care, probably the two most common that I see, much more common. Retail banks, some financial institutions, but not like retail or a lot of other industries where you just don't have a daily list of HIPAA violations where people overhear them talking in a hospital and someone complains about it. That's tagged as a HIPAA violation, gets logged somewhere. And as Sarah said, understanding the client, understanding their processes in place before I'll even recommend to a customer that we look at doing and putting bordereau language into a policy. I first want to know, how do you track them internally today? How do you code those? What are the levels? Are there various incident response triggers in there? Who keeps that list? How easily can we get a list that'll help determine, is this an annual, a semi-quarterly? Obviously, we want to make it easy on everybody, carrier, the claims folks, the broker, the client. You want to make it as streamlined as possible, but informational. And so that's really where that becomes helpful when you do have multiple claims frequently.
So, hey, go ahead, Sarah.
I was just going to say also, you want what the policy says to actually reflect what's possible in reality. So I know, I have conversations with underwriters a lot, and it's like, well, we want to know about everything. We want you to tell us about every incident. Do you? And is that even a real possibility? So I think it's just about setting everybody up for success by making the words actually reflect what's going on.
And I think there was an earlier comment about underwriter not getting his hands dirty. So maybe easy to say, I want to know about everything. In terms of practicality, maybe not. But Suhei, speaking of underwriting, one of the pieces of conventional wisdom for people that are shy about giving notice is, well, if I give notice of the small thing or I give notice of circumstances, then Suhei's going to go running over to the underwriting department right afterwards and tell them, jack up my premium for the next year or drop me as a policyholder. Can you address that conventional wisdom?
Sure. Well, from the claims handling perspective, I'll say we treat notice of circumstances pretty similarly to how we do a claim. And the reason being is when these incidents get reported, very often the insured doesn't have a lot of information at its disposal. It's still undergoing its internal investigations. And in some instances, depending on the policyholder, they might not even be sure what their next step should be or who they should be speaking to. So even if we get a notice of circumstance that's reported and it necessarily doesn't trigger the definition of a claim, we can provide the policyholders with those resources and place them in the right direction, put them in contact with those breach coaches or with that forensic investigator to get, if there's a network intrusion, get that investigation going. And to the extent that it turns into something larger, they're steps ahead of the game. I'll say I've also seen situations where incidents were reported as a notice of circumstance, but lo and behold, based on the information that was provided, it was an actual claim. I know you mentioned the concern with premium, and I certainly think that's more of an underwriting-focused question, but there are also other advantages to reporting an incident as a notice of circumstance. If a company, for example, properly notices a circumstance, the carrier will generally treat any subsequent claims arising out of that circumstance or incident to have been made during the policy period when that notice was provided. The benefit of that is that if you later have a claim that transpires after the expiration of that policy period, it's going to get covered under that prior policy, and it's not going to impair any subsequent policy limits. You also don't want to run into the situation where you think it's much ado about nothing, but then you later learn, hey, this is going to, or it does blow up and become a larger issue, and you come against the issue of late notice because you didn't report that incident earlier on.
If I can just give the opposing party's response to that, good stuff. No. So there's some drawbacks in reporting a notice of circumstance, and when I'm saying notice of circumstance that could give rise to a claim, either side of the policy, either the breach response side or the liability side, can have those types of situations. Without getting too deep in the weeds, you find some hacker tools on the system. If there's hacker tools inside your network somewhere, that means something bad's gone on somewhere. You don't know how bad it is yet. That's a circumstance that we could argue that, anyways, let's just say that for there. On the other side, it could be a simple a phone call where somebody calls a call center and complains about something. Hey, you've done this. You've breached my thing because you're the only people who knew about this, and now I'm getting all this junk mail, so I'm holding you responsible. What are you going to do about it? Well, that's not exactly a claim, an oral complaint on a call in line. So those kind of situations could be just a couple of the many examples. Oftentimes, if you're tracking that information, it's a good idea to report those by the end of the policy period. If you decide that it's wise to do that, again, talk with your counsel, consult with your broker for policyholders. But usually wait till the end of the policy period. You'll know a lot more then, and you'll probably be able to cross a lot of those things off at that point because there's no requirement in most policies. Again, I'm speaking general cyber language. Your actual mileage may vary. There's I've never seen this done myself, but my claims attorneys have said sometimes a notice of circumstance can be rejected. Basically, you say, we have a feeling that something bad could be coming, but we really have no more useful information to provide to you. I've been told there's circumstances where a claims adjuster could say, okay, you know what, we're not accepting this as a note. There's not enough information for us to even put the timestamp in here and start tracking this and backdating anything that comes from it. So we're rejecting it. Well, now what do we have? We've got an issue where we haven't reported, and now we maybe have to report again, and you have some timing issues. So those are just some of the maybe more infrequent concerns about it, but it is just something to think about. That sometimes us brokers don't always think about, that the claims attorneys get more involved in. Is that fair?
Yes.
Okay. Thanks.
All right, so perhaps the most interesting topic here, what happened to my policy limit and sublimits? Certainly, when you're dealing with other policies in the market outside of third-party liability, such as first-party property policies, there can be sublimits for floods, for earthquakes, for otherwise. But cyber insurance, depending upon the form, depending upon the pressure given by the broker, can have multiple sublimits. Regulatory is one I've seen most frequently, costs of PR or otherwise, and other things that are more difficult to wrestle with. And so, Sarah and Tom, from my perspective, the easiest thing to say to policyholders is, hey, buy a policy without sublimits. Because I get to sit at my desk and write these blog posts or articles and say, well, that's what you should totally do. But you're the ones boots on the ground, if you will, that deal with people trying to buy insurance policies and seeing the state of the market. So can you tell us about the state of the market regarding sublimits and what people can expect from policyholders large and small?
I'll
Would you
start.
go first?
Yeah, so this is where I get to plug the London market, where we have sublimits much less frequently. But I think that there's definitely a trade-off in a lot of cases where if you, and this is generally kind of predicated size of insured, whether or not you are interested in taking a much higher retention so that you can then get full limits for everything, or whether you say, actually, it's much more important to me to have protection lower down, and then I'm willing to go with sublimits. But it's always the debate you have. And then there's the whole issue of building excess, and are you able to get kind of drop-down sublimits to top up what you don't get in the primary then? My view is almost always to push towards no sublimits, but not always achievable. I mean, I think that in terms of sublimits that we get pushback on the most, I think PCI is a big one right now that almost nobody will move on. You still do see the regulatory and the kind of PR incident management costs, but more and more willingness to give full limit coverage if you're taking an appropriate retention.
Ditto.
Are you seeing efforts to fill in a so-called donut hole between the aggregate limit ultimately of the primary versus the sublimit and then your excess coverage being willing to drop down, or is it an unfilled hole between the two? What's the most common way of handling those, if there's a common way?
I think the most common way is to try to build sort of like a tower within a tower. So you have your sublimits stacked up separately and all your excess carriers providing that. But obviously that's just a matter of pricing and attachment point, whether anyone's going to be willing to give you that cover. So, obviously easier if you don't have to do that. And then if you think about, okay, what do we have to, if we're on BBR, do we have to top up on a per person basis outside of the limit? Then that becomes a more interesting and sort of difficult discussion. So, you really do have to think about what your overall program goals are, what you're trying to achieve in the end, and not just focus on, okay, let's choose the primary and then we'll move on to everything else. You really need to think about, is what you're getting in the primary going to be enough, and how are we going to have a sustainable program above it?
I agree. It's nice to just say, let's just do a full limit policy over everything. You got to take a big deductible typically to do that, and those are nice policies, and you can build hundreds of millions of capacity and not worry about drop downs and all that aggravation. But there are times, especially when you get into the technology and telecom world, especially retail as well, where you don't have to worry about certain sublimits, and so you can accept those as kind of strategic sublimits or intentional sublimits in the program because they're not meaningful to that client. So again, knowing your client, understanding their organization and their risk. I see a lot of times just confusion on, I hate this word, first-party notification, right? So the notice and credit monitoring and all that garbage stuff, important aspects of the policy. I forget there's vendors here too, sorry. But that important stuff for a company who's a data processor or a cloud company who has no access to the records, or point of sale retailer who doesn't take any personal information beyond the credit card for a split second that it's in their system before it's gone, they don't have the ability to notify. So getting full limits for upfront direct, first party, hate that word, notification expenses really isn't all that important. It's going to be done by somebody else in a lot of those scenarios, and so you need more liability limits there. So really understanding your client's exposure can really help you understand, do we need to worry about all these crazy sublimits, or can we deal with strategic sublimits?
Mary,
that's a new trademark term.
one question.
Yeah.
One question for you is, I know a lot of clients renew all their policies, so 10 plus policies at the same time every year.
42.
How much time does that afford you at the time that you're binding? Or a typical policyholder, how much time is afforded in their day to say, let's get into the weeds of what's going to happen about the known knowns, like a regulatory action, or how much PR cover do I have, or something like that, versus saying, holy cow, it's June 1, and I have 50, 40, 10 policies to renew all at once. How much time can be drilled down, even with a full-time risk manager?
So I think you probably already know that answer.
It was a leading question.
the stack, and I almost brought just a show, but I didn't want to pay for an extra suitcase, so I chose not to. But I have a stack of binders that is this tall, 6 big binders, that has our 42 different insurance policies. And we are in the process of negotiating and getting those policies right down to the wire. Many of them even, are kind of in draft form when you go to commit to bind the policy, and you don't get what really it was until maybe 6 weeks later. The whole point to that is, we don't know every in and out of what it's going to be, and that's why we rely on the specialties of our broker to know who we are and to know what's important to us. And so, when I referred before that we use outside specialty counsel for special issues, that's how we view our relationship with our broker.
And that's a plug for experienced brokers, is that you have the opportunity to have the experience to come in and say, here's what I've seen, here's how I suggest we push back, and work with your policyholder to say, is this important to you or is it not? And so, as Tom was mentioning, the question of some organizations won't have concerns about, or will have far lower in terms of concerns about certain things, like do they have this kind of data, and if they don't, or they think that they don't, isn't always they think they don't, and they don't have a risk of that. So if you're completely outside of retail, you're not consumer facing whatsoever, do you have payment cards, or do you have health information versus trade secrets and governmental information that you don't want to have disclosed? So if you're for example, if you're a defense contractor, their interest in a policy is wildly different, and it puts a broker in an interesting spot compared to writing a flower shop or someone else.
And I'll add to, we may consider ourselves somewhat a little bit more well-versed in what happens with a data breach now, but we weren't, 2-3 years ago. And that's why we had, it's important to us to say, okay, we don't know what to expect. We don't know what kind of twists and turns that this episode may take, and having someone that can ask you those questions is critical.
I think ultimately, I don't know if there's anybody in the room that underwrote or is part of the tower that covered Wyndham, but would love to know what their regulatory supplement was, if anything, and if it applied to that litigation, because that's certainly not inexpensive.
Was that a question to the audience?
Rhetorical.
Rhetorical question. Got it. Okay.
So, moving on to incident preparedness, ideally. Here we go. Let's envision a perfect world. Sue, hey, tell me about your perfect world where ice cream's free, gas is cheap, and my kids let me sleep a full... Wait, sorry, that was me. Back to cyber insurance. Can you tell us about some high-level issues that led to more troublesome and costly incident response scenarios that if you were able to go back in time like Superman and spin the world backwards, you could have fixed it before everything got ugly?
Sure. You mentioned kids sleeping, but I have a 2-year-old at home, so I think sleeping is overrated.
This is probably the most sleep you're going to get while you're here.
I do. And we talk about, and you mentioned it early, really the breach response happens pre-incident, or it should at least. And we often hear how important it is and vital to have an incident response plan in place, one that's flexible, one that's comprehensive. And I think one of the things that it should, among other things, have is identifying who those decision makers are on behalf of our corporation, who can make decisions on the fly when there is a breach. One of the issues that I've seen arise is when we engage in calls with our policyholders and we don't have access to those decision makers, or it's unclear who they are. And that has, in certain instances, hampered the incident response process as a result. Another issue is, and we mentioned it before, the use of inexperienced providers or professionals. And I've certainly seen issues arise where the policyholders have utilized the counsel of their choosing, but given their inexperience with handling breach response, mistakes have been made. So you're getting notification letters that are being sent out that are not in compliance with the different state law obligations as to what should or shouldn't be in those letters. And another issue with timing, where those notification letters are being sent out on an untimely basis. And that in and of itself exposes the policyholder to further exposure, especially in the third-party side. We know the plaintiffs bar, one of their favorite theories to basically allege is that there was untimely notice. If you're looking at the regulatory side as well, regulators tend to be more aggressive and tend to pay more closer scrutiny when they find or they believe that their own notification laws were not adhered to, whether it's basically the policyholders didn't provide that timely notice or those notification letters weren't in compliance. And we talk about the importance of having the right vendors in place, but another issue that I'm seeing conversely on the other side is where the policyholders want to manage their SIR more than they do the actual incident. So we'll get a report of a claim, and there's an actual issue here, something that should be dealt with, and policyholders don't want to engage that counsel or the forensic vendors to come in and investigate to figure out, hey, do we really have an incident here? And that can expose them to further exposure on the other side, for sure.
Mary, let's take it from the policyholder's particular perspective. Cyber specific, perhaps compared to others, have you or other people you've talked to, have you called up in advance of an incident and said, hey, let's have a get to know you conversation with the claims department?
We have not done it with cyber. We regularly do it with workers' comp, GL, professional liability. We, particularly when we have a dedicated claims staff that services our account, and we do that in advance. Again, though, we've relied on our broker for the assessment of, with cyber in the past of, claims handling experience, overall reputation or thoughts about. So we haven't as to cyber, but we do as to others.
Now,
If I can just
go ahead, please. Yeah.
From the cyber side, I would get frequently or on a routine basis on different calls with our underwriters and with policyholders, brokers, where they wanted to learn about the claims process and what they can anticipate in the event that there is a claim. In certain instances, I've had discussions with them pre-incident about, they're looking to renew policies, and they've brought claims folks on to discuss potential vendors that they were looking to utilize or to get more information on the vendors that we provide. So it does happen as well on the cyber side.
Tom, Sarah, have you seen that? Have you seen policyholders that have said, hey, I want to know your claims department and who I'll be dealing with in advance? Or is it 10? Can you tell us about that?
Yeah. Yes.
Please do.
No, clearly, I think, especially sophisticated buyers, folks, very few organizations today have never gone through. To get my double negatives here right. Everyone's had a breach of some sort, I think is what I'm trying to say, or some kind of event or a close call. So that's becoming much more common that they're interested in having that conversation, meeting those folks. Could be also a function of the market. I almost said the word hardening. I can't say that in the market's real soft. That's what we say, right, brokers? Market's soft
So
still.
soft.
Right,
Get
so
everything
soft,
done.
so very soft. But the function of the marketplace forces that are happening out there right now that we see a lot of our clients very excited when we recommend them meet claims folks from the carriers more than they have historically the last 10 or so years.
I mean, I think it's definitely best practice to do that. I don't think it always happens, and it especially doesn't always happen first time buying. But certainly as you're developing a continuing relationship with an insurer, really important to have that ongoing relationship with the claims team as much as with your underwriter.
All right. How do we get people up to speed and avoid trapdoors? Sarah, I don't know if you've thought about perhaps 3 tips to onboard a policyholder so that worst case scenario, where they're set up for success if an incident does affect them.
Why, yes, I have thought about that. So I think, first of all, we kind of talked about this earlier, and that is when you're first putting a policy in place, it is really getting a multi-stakeholder group that is involved in matching up what's the policy going to say and what's it going to cover with the reality of the company and the situation and what's going to be realistic to to report, and also what are the priorities. So having had that conversation in advance, then the next thing that you really need to do is to bake in insurance reporting and awareness into that incident response plan, so that, in the event that, it's not all kind of part of the same department, that Mary does get the call to report it into the insurer when that's occurring. And I think it's even useful if your client has regular incident response planning tabletops, right, to get the insurer, to get the broker, to get those vendors that will be involved to be part of that up front. And then finally, it's one thing for us to say you should read your policy and know what's covered, but it's also a very new type of insurance for a lot of insureds. And there's a disconnect as well between what cyber means in the minds of all of us in this room and what it means in the minds of an information security person. I think there's much more focus, in the information security world on cyber means bad guys outside trying to get in. And actually what we've talked about so many times today is human error and all of the other things that can go wrong that actually can be covered under this policy. So generating that awareness so that it's not necessarily something happened and you intentionally didn't report it. It's more you may not have even known that there was a possibility for coverage. And so that education process has got to be part of that onboarding, and it probably can't just be one time for a new purchaser. It is, something that has to become ingrained and has to become sort of second nature for that team that's doing the incident response.
Tom, anything to add to that?
Yeah, if for the brokers in the room, if you're not a policy wonk, get to be one, and spend time reading through the policies with your clients. We joke that that's the most fun 6 hours we spend with them on an annual basis, sitting down and flipping page by page. But they'll bring in different folks around the organization. Again, everything Sarah said was right on. And so I would add that. And then I would just reinforce that those 3 tips that she gave, utilize those as you prepare the policy, as you pick the carrier and the policy form and the endorsements, and understand the client, understand the process that they go through there with their multidisciplinary group that's going to be reacting and working with this policy over the next several years, and you utilize that information, that knowledge as you build the policy.
Mary, I know budgets are tightening and people are thinking about buying insurance, and everyone's facing the obligation to do more with less. So when you're thinking about buying cyber insurance, how do you view a price compared to broker comments on reputation or word on the street about how claims are handled and policyholders are treated?
So it's a balancing. It's not just price. We also benchmark ourselves against industry peers with similar, net sales, net profits. Are we over-indexed? Are we under-indexed? As far as insurance, we also find out what's the claims handling experience, what's the reputation. And so it's not any one. If we have a policy that has favorable sublimits and fewer exclusions, we might defer to that policy over someone that has, a really good claims handling reputation. So for us, it's the input of, a multitude of factors before we make that decision, and it's never just price.
Sarah, I've heard the phrase lazy underwriting. I don't want to throw anybody under the bus and say where I heard that from, but tell me about things that you're seeing in the market regarding things like what made the news, alleged failure to follow reasonable security practices, or attaching an application to policy and requiring a warranty. What are you seeing out there for what some might call lazy underwriting, and other claims people would say, well, that's perfectly reasonable?
Yeah, I mean, so I think you have those exclusions in policies, which are, you didn't do exactly what you said you did in your application. And by the way, your application was 3 meetings, a conference call, and 25 policies that you handed to the insurer. So not doing exactly what every piece of those documents said is completely reasonable in a large organization responding to a dynamic threat. So having that kind of exclusion just seems completely unrealistic to me. Or exclusions for things like, losing unencrypted data. Anything like that, right? If you ask the underwriting questions around those issues and get comfortable with what the compensating controls are, you should be able to eliminate those exclusions and just price for the risk that you're taking on. Now, you could call that lazy underwriting. I think it's probably just as often an inability to get the information. So it's not that the questions aren't being asked. It's not that you don't want to get to a solution of providing cover that doesn't have that type of exclusion. But I think it can be challenging because I really think we got to a point in the market a few years ago where underwriting, due diligence, there was so much competition in the market and so many new buyers that it was just easy to get policies bound without any detail. And now we're swinging back to a point of more due diligence, which I think is a great thing for the sustainability of the market in general. But it means you have to provide more information in order to get broader cover. But certainly if you're going to spend that money, right, you want the quality. So certainly a balance to be struck.
We have a couple minutes left. I'll stop here. I have some more questions with the panel. So I want to see if there are other questions in the audience that I'd like to have answered with a few minutes left to go. Now we stumped everybody.
Everybody's hungry. That's really what it is.
I'm hungry.
Tom, let me do this as a rapid question so you get to close the show.
He's the funny guy.
You're going off script now. I don't have a rap.
The question is, when you're dealing with companies who are focusing on price and saying, hey, this is all I have to spend this year and I've got to bring it in exactly where we were last year, what do you tell them and how do you handle that?
Oh my God, he doesn't have an answer.
I know. When there's a fixed budget, we just need to adjust our expectations. Maybe our limits are going down. Maybe our modules are going down. Maybe we're going to drop some of the system failure, administrative error coverage that we hopefully haven't had a claim on. So just adjusting the policy to meet that. I frankly don't, I'm a little stumped because I don't have too many situations. I don't deal with a lot of government entities, so that probably could be why too. But where price budget is it. That's number one. We can't spend a nickel more than X on this renewal. Again, we try and give across insurance in the risk management world as various lines of coverage go up and down as the market moves, as competition moves. Try and give your clients as much advance reasonable notice as possible on what might happen, so for budgeting purposes. But no, I mean, there's no. I don't think there isn't any magic answer to dealing with a pure price buyer. They're out there. Clearly, there are organizations whose mission, who their mission to their customers are, we cut the prices out, and that's their business model, and they bring that to their service providers and vendors and insurers and lawyers. How do you deal with a client that has a price per hour that they just won't pay you?
It's always a fight. I tell them,
there's the answer.
I'm so valuable. I'm so valuable. All right. Well, so basically what you're saying is professional experience trumps all.
Sure. Let's go with that.
All right. That's all the questions that I've had for the panelists. Thank you, everybody, for attending. And I know you had your choice of sessions, and we always want to thank you for choosing this one.
Thank you.